So last week, episode 29, our first ever remote episode, we talked about Hermes. We talked about large luxury fashion brands throughout the world. We realized that there's sort of about 5 or 6 that control the whole market. And one of the more long-standing, editions of those is Hermes. Now, interestingly enough, Hermes has there's an interesting case that just finalized between when we recorded the last episode and me speaking now, and it's in regards to NFTs and it relates to Hermes. Are you aware of this at all?
No, I'm not sure.
Okay, fantastic. It's worth being aware of. This is what's called a precedent case. So it's based in the US, and it basically has set what you could potentially consider to be new law, judge-made law, in relation to NFTs in America.
Interesting.
So for those, just very briefly, in regards to law, in common law countries, which is countries such as the US and Australia and the UK and others, law is made in 2 ways. Do you know what those 2 ways are?
Legislative and common law court cases.
Yeah, that's right. So case law, that's right. So judges make them and legislatures make it. And so the courts can make it much faster. It doesn't have to go through Parliament and through the bill process. And so this is an example of that. So this is how the law can change and adapt with societal expectations and changes. So for those of you who haven't watched last episode, let me give you a quick little rundown here. So Hermes. They're a luxury brand. They're known for, among a few things, we talked about the Birkin Bag. Remember the Birkin Bag?
Yeah.
Last week. I went and found a few figures, right? So yeah, in the US alone, they've sold more than $1 billion USD in revenue worth of just Birkin bags.
Yeah, right.
Which is pretty significant since its inception. And they regularly sell, for those who weren't watching last week, for somewhere around 10 to 15,000 US dollars. Generally speaking, although there's some outliers in that regard. And very much so the bags, and these are important topics when we get to the case in a second. The bags are very much ingrained in culture, right? And they very much represent wealth and exclusivity, right?
Absolutely.
And interestingly enough, it's worth noting that Hermes has trademarked both the word Birkin and the shape of the bag. So now there's an NFT project which you can go and look up, and it's called MetaBirkin. If you've got your laptop there, you may as well have a look, right? And so this was created by an individual named Mason Rothschild, and it was basically a collection of 100 blurry, furry images of digital Birkin bags. And so basically the mint price for these when it first came out in December 2021 was equivalent to $450 US, which is pretty significant dollars for, an image. But, in those times, that's what was happening.
It's I'm looking at a furry bag with a banana taped to it.
Perfect. So, okay, that's a good example. Some of these images have sold for upwards of $40,000 in the secondary market right around mint time, which is sort of often when the hype is really happening. So that's context on Hermes, and that's context on this completely separate, and it's important to make that note, completely separate collection created by a completely separate individual. Okay? This guy's an artist in LA. He's done a bunch of other things, and he's created this collection.
Right. So he's not involved or associated with
He is not involved
Hermes.
or associated with Hermes. Now, there is some, information out there stating that he did approach Hermes to try and see if they'd be a part of it. If that's true, they certainly didn't agree to be a part of it.
And that's almost worse because it means he knowingly asked them to be a part of it and they've said no.
That's right. It's sort of equivalent to asking your parents if you can do something and then they say no and then you go and do it.
Yeah.
It's much worse than if you just hadn't have asked them.
Yeah.
I think every kid knows that.
Yeah.
So I'm not sure if that's true or not, but it's possibly true. So basically what happened was 3rd of December 2021, the collection drops. 16th of December, so sort of 2 weeks later, Hermes sent Rothschild a cease-and-desist letter, right? Basically alleging that MetaBirkins NFT collection had infringed on their trademark. Remember what did I say they trademarked?
They trademarked both the shape of the bag and the name of the bag.
Yeah, exactly.
Did you say his name is Nathan Rothschild?
No.
Okay.
Mason.
Mason Rothschild. Okay.
So
I thought it was the really famous descendant of the Rothschilds.
No. That's a good question. First of all, there's no S on the end, so I think it might be like a totally different family. Because is it Rothschild or is it Rothschilds?
No, well, Rothschild is the famous name.
Oh, okay. Well,
so is it like oh no, this is Rothschild.
That is how you spell it.
Yeah.
That's how you spell this guy's name.
Right,
too.
okay.
I don't know if he's some sort of descendant.
This is the banking empire.
Yes, that's right.
Yeah, okay.
I don't know if it's related.
Right, okay.
Tell us in the comments if it's related.
Okay, cool. Sounds good.
So at that time, he got a cease and desist letter. That was also sent to OpenSea because it was obviously listed on OpenSea as the collection. And so OpenSea did remove it at that time. And Rothschild argued that his NFT collection was protected by the First Amendment.
Okay.
Which basically
freedom of speech.
Exactly, just freedom of speech. And he was saying that it was giving him the freedom to create art based on his own interpretation of the world as he saw it around him. Okay, so that's a very broad general statement. And so you'll be able to see here, hopefully, I've got the letter. He published the letter that he sent back to Hermes.
Yep.
And so he's put it on his Instagram so that you can read that now if you're watching the video version of this. It basically just says what I've told you there in regards to him creating art. So now on 14th of January, 2022, Hermes had enough, right? So this is sort of circa a month later. So Hermes brought a lawsuit to the New York federal court, and they were seeking damages. Now, do you know what I mean by damages? I don't know.
Seeking damages means that essentially you're hoping for a payment for the damage to your brand, or in this case, the damage to your brand.
Exactly. So damages is just monetary compensation. And so the calculation what they were claiming was damages for the profits that he had made off Trademark that they owned.
Yeah.
Okay.
Absolutely.
Great. And on top of that, they were seeking an injunction. Do you know what an injunction is?
I'm not sure. Is that a cease and desist on stopping business?
Yes. So basically an injunction just prevents someone from doing something that they're going to do.
Yeah.
So in this situation, the injunction is to stop the sale of the collection on OpenSea and on his platform.
Yeah.
Okay. So there's a cease and desist stop order that they're seeking, and they're seeking some monetary compensation.
Yeah. Also, I've looked up, his real name is Sonny Estival, and it looks like he's just using the Rothschild name, which might be another cease and desist case in the making, I think.
Okay, interesting.
Yeah.
Okay, so the Hermes suit was based on three things. You ready? Trademark infringement.
Trademark infringement.
We know what that is, so that's based on the word and also based on the shape of the bag.
Causation.
No.
Oh. Legislation.
Stop saying legal words. Dilution, which is an interesting one. So dilution is basically saying that use of the word Birkin has damaged their distinct quality that's associated with their brand.
Yeah.
Okay. So it's almost like, goodwill. It's sort of like saying, listen, we had this goodwill built up. Now you've defamed that goodwill to a certain extent.
Yeah.
And so we want some compensation for that. And the final one, I don't know a lot about, but it's interesting. It's called cyber squatting.
Cyber squatting.
So it's the use of a similar domain name that may be confusing to consumers. And so he was using the domain name www.metabirkins.com.
Right.
And so they were just claiming that that's confusing. Maybe not such a good argument because their domain would not have been anything to do with Birkins. It would have been something about Hermes.
Yeah.
But it's an interesting claim. So they also mentioned that, so we've seen a lot of luxury brands come into the NFT space, right? So if you look online, there's a few that have created some collections. And Hermes also claimed, generally speaking, that Rothschild's or Mason's project had also disrupted their future endeavors to be a part of the NFT space because now consumers are confused as to who owns what and what's going on, right?
Yep.
So then after this lawsuit is filed, Hermes releases another letter to his community this time on Instagram. Again, we'll post that. And it basically argues his point regarding free speech, et cetera, talks about Hermes not being up to date with the times, et cetera, like that, trying to intimidate him, stuff like that. So now, it's worth noting this, right? I'm hoping this is a little bit interesting for some people who are interested in how the law works. So basically, in the US, they use a jury is not always in place.
Yeah.
But where there's a significant issue of fact, which means there's two sides to a story, and we need to figure out what actually happened in the situation, oftentimes that goes to a jury for them to make a decision as to what they think actually happened. Okay? So in this situation, basically, there was so many issues of fact in regards to what was his intentions, who said what to who about how much he was going to sell stuff for, and et cetera, that the judge who originally saw this case decided that he couldn't decide those issues of fact.
Yep.
And so he sent it to a jury. Now, the issue with sending a case to a jury is that they don't write a judgment when they make their decision.
Yeah. So
right?
Does that mean that it's harder to put the common law case into writing? Or?
Well, yes, it's harder to understand what their reasoning was as to why someone won or lost a case, right? Because they don't publish it. And in Australia particularly, you're actually not allowed to know any reasoning as to why they made their decision.
Okay, interesting. So that would be difficult to ratify then.
Yes, it's it's difficult to pull any principles from the case. So basically what we've got here instead is the judge's summary judgment. So just before it went to the jury, both parties asked the judge to look at the case, just paraphrasing here, to see whether he could summarily, which means just as a single judge, make a decision and make a determination. At the end, he decides that he can't and needs to go to a jury, but we can use this case. He pulls a lot of legal principles and reasoning out, okay? And I honestly think it's going to be really interesting. It's not very long at all. I've summarized it quite well, I think. Okay, so basically both parties wanted this summary judgment, and so it doesn't always have to happen, but they both raised a motion for a summary judgment. And so there's two tests, okay? Law often works like this. The tests are based on previous cases. So the first test is called the Rogers and Grimaldi test, okay?
All right.
And so this is a test used for any piece of material that is determined as an artistic work. So if you can first determine that it's artistic in nature, intentionally artistic, et cetera, then it can fall into this test to see whether it's infringed on someone's intellectual property. Now, if it's determined as a commercial product, for example, then it falls into a second test. And that test is Gruner and Jar. Okay?
Okay.
So
you
have to
people names?
These are case names.
Yeah, case names, yeah.
In the same way that the name of this case is Rothschilds and Hermes.
Yeah.
Okay, so there would be a principle coming from this case. So first of all, we need to figure out which one it goes into. So now, a few interesting other points on this is that I think this is really interesting. So when Rothschilds released the collection, he retained ownership of the smart contract.
Okay.
So what that meant, and I don't know the technical details here, but what that essentially meant was that when people were looking at it on the website or on OpenSea, well, probably on his website when it was minting, all they could see was a white sheet over what appeared to be a bag, but they couldn't see the specific bag because, as with a lot of these mints, you can't choose which one you get. It's a bit of a gamble.
Yeah.
Right? Because some of them have bananas, some of them have whatever, right?
Yeah.
And then
they've all got different rarity and stuff.
Exactly. And so then when you have minted, then he, on the back end, as I would call it, swaps the image, like manually swaps the image to an actual image of whatever Birkin bag you get.
Yeah.
Which is just an interesting point. I didn't realize that was possible. Essentially what that means is he still retains the power to do that in the future, which is very strange.
Yeah, right.
It almost makes it seem like quite a facade. But anyway, so total sales for his collections were just over $1 million USD. And he retained, remember creator royalties?
Yeah.
Remember what that is?
Yes.
So basically when it on sells in the secondary markets, he still retains, in this situation, 7.5% of any of those future sales.
Yeah, that makes sense. Yeah.
Okay. So that's just a little bit more background on his particular collection. So the court looks at the characteristics of artistic expression. Okay, so remember we said if it's artistic, it goes into the Rogers case. If it is commercial, it goes into the Gruner case.
Okay.
So the Rogers case originally came from a movie. You can look it up. It's called Ginger and Fred. It's a 1986 movie that came out that had infringed on some intellectual property, and it was deemed to be artistic expression. And so there was a bunch of principles that were put in place to determine whether or not that was actually infringed on someone's intellectual property. The question is, if the primary purpose of the creation of whatever the content is or the material is commercial, then as I said, it falls into the Grenier case. And so that particular case just involves, it's very simple. It just involves assessing whether the defendant's conduct confuses customers as to the source of the product. So if it's deemed to be commercial and it's confusing as to who actually created it, it can be deemed as infringing on intellectual property rights, and the person who's making that claim will probably, get some sort of remedy, i.e. damages.
Makes sense.
So the court said in this situation that the judge decided that the Rogers case was potentially most applicable. Now, that was the one that's related to artistic works. Now, you have to look at everything here through this lens. What we're deciding here is not related to this collection necessarily. What we're deciding in this situation is, are NFTs art or a commercial product?
Of course.
And this is significant. And so basically the Rogers test, the judge said the Rogers test applies as the primary purpose was made for artistic purposes, and it didn't necessarily mislead consumers as to its affiliation with Hermes. Okay? And so in that situation, it's most likely that it will be protected by the First Amendment. And so the judge...
So it is artistic.
Well, wait.
Interesting.
So there's a really interesting quote here. So it says this, ready? First Amendment protects right to speak against a trademark holder. So in that situation, he's basically trying to make a point in making them furry. He's trying to say that making them fluffy bags, he's trying to say like the use of natural materials, like i.e. like animal skin is bad. So he's trying to make like an artistic point on that, right?
Yeah, right.
So it says the First Amendment protects the right to speak out against the mark holder, but it doesn't permit a suggestion that the mark holder is the one speaking.
Wow.
Very interesting phrase. Basically means you can't pretend that the company that you're creating the art to sort of look like is actually behind it, right? Okay. So they consider that the Rogers test could apply because it constituted a form of artistic expression and it didn't primarily mislead the consumers potentially. There was a bunch of evidence from interviews from Rothschild showing that he really did have an intention to make that sort of statement about natural products and natural materials. However, Hermes presented a bunch of evidence of communication that demonstrated Rothschild's ulterior intention to simply just make big money from the project. And so the court found that while making money was a motive, it may not necessarily have amounted to the primary motive, which was the key here. And so, for example, the court said that the court wouldn't necessarily strip an artist of its First Amendment rights just because it was seeking, some monetary value from what it made. You know, the movie, for example, sold in the box office, but it was still an artistic creation, right?
Yeah, okay. So the primary motivator wasn't to make money.
Correct. But there was some money made.
Yes, that's right.
And that's reasonable.
And so you just can happen to make money from art without having a commercial purpose.
Correct. One interesting quote from the court says, the court should not expect the First Amendment applies only to works of starving artists whose soul's mission is to share their artistic vision with the world. Interesting.
Okay, so they don't have to be starving. So
correct.
They can be very rich artists.
Yeah, you could read it as that. So basically at the end of this, the court says, well, okay, there's contradicting evidence here that points to a potential issue of fact. So we're trying to decide on what his actual intention motive was. Therefore, this is potentially more relevant for a jury. Now, the second question here is, okay, so if we do assume that the Rogers test applies, it's artistic expression, is it actually protected by First Amendment rights? So what is the result of this Rogers test? Now, the court in Rogers stated this: in certain instances, the public's interest in avoiding competitive exploitation or consumer confusion outweighs First Amendment concerns. So basically what that means is the public's interest in ensuring that they're not confused is potentially more important than the artist's right to the freedom of speech, right?
Yeah, absolutely. So
it said, okay, there's two things to consider as to whether the Rogers test is approved. The first one is the artistic relevance. So is use of the trademark artistically relevant to the underlying work? Did it need to be used? Did the trademark need to be used to make whatever artistic expression was made? So it's a really easy test. It basically is satisfied unless the mark has no artistic relevance whatsoever. In this situation, you'd say, yeah, it does have some relevance because he's trying to make a point about Hermes. So he needs to use some things that obviously show Hermes. So, okay. Although to a certain extent, it's a question of fact. And so maybe, again, not relevant for a summary judgment. The second question in the Rogers test is it explicitly misleading? Okay, so the trademark must use explicitly misleading language, or connote something that is explicitly misleading to the public as to who created the work. And basically, that's satisfied if it convinces the public that it was authorized by Hermes. Now, there's a case that answers this question. It's called Polaroid. It's from 1961. It was two companies. One of them had they called their company Polaroid. The other one called it Polarad. And there was a claim as to whether or not that confused the public. And there was a bunch of factors to be considered. Some of them are the sophistication of the relevant consumers, quality of the mark, etc. Basically, the parties didn't agree on all of these factors as to whether or not it was misleading. And once again, it was a genuine issue of fact. And as I said, that's better decided by a jury. So basically the judge puts his hands up and he goes, listen, there's all of these issues that are issues of fact of what actually happened, who had what intention. But he's really nicely outlined all of the tests, and he said, he's basically outlined how he thinks it should be decided. Now, so then it goes to trial, right? Goes to trial 14th of February, 2023. That's very recently. That's less than a month ago.
Yeah.
Right? And so the jury found, this is interesting, right? Remember what the judge said. The judge said it was artistic expression, most likely protected by the First Amendment rights, etc.
Yeah.
Jury found Rothschild's primary motive was commercial.
Okay, yeah. So he was trying to make money.
Indicating that the resulting NFTs were more similar to a consumer product than art. And it was therefore subject to the stricter Gruner test, which simply requires customer confusion as to the source of the work. That's it.
Wow, okay.
The jury found that consumers were or would have been sufficiently confused as to the source of the work, and therefore the court awarded Hermes over $100,000 in damages, which is small considering the fact that, we said that I think he did more than $1 million in revenue, but that's certainly still a very good indication. So what does that mean for the future? So Hermes and Rothschild's potentially, we have to see how the courts use this case, but it may be a precedent for NFT collections being able to be classified as commercialized products, rather than mere artistic expression.
And if you take it one step further, it's almost like you can take them and turn them into securities and have them regulated by the SEC.
Totally. So what does that mean for current NFT collections? So it should mean that current artistic collections should consider how they can basically stop consumers from being confused as to whether or not it's endorsed by some sort of mark that they're using, by a prominent disclaimer or press releases, etc. Then in my head, that should solve that issue. Because remember, the test is just a consumer is going to be confused. And so it's interesting. Now, just leading off this, have you heard of StockX?
Yes.
Okay,
yeah.
so you know what it does?
Yeah, so essentially you can buy sneakers and Rolexes and things like that, and basically it's like a little stock market. So they have a price tracker on them.
Yes.
They've got the bid-ask price, and essentially it'll show price tracking over time as though you're looking at a stock. Correct.
So that's right. So let's focus on the sneaker element of it for a moment here. Now, have you heard of their Vault project?
I haven't, no.
You may have heard of it.
Is this basically where they're taking the items and putting them in a vault, and
what do you get?
don't actually, you get a token which represents
the
value.
You get an NFT,
yeah,
which represents the product, which is in their vault.
Yeah.
Okay, so summary of that is basically it's still all secondary. So if someone sells, my understanding actually is that StockX actually purchases on the secondary market a bunch of shoes, or at least facilitates the transaction. And turns them into NFTs, so takes photos, blah, 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 lists them as whatever they are, puts photos up, and people can purchase them. I could purchase one, for example, usually large amounts of money, maybe $500. It sits in the vault. The benefit of that is it makes it highly liquid, easy to transfer. I can then sell it and invest in shoes without having to worry about shipping and getting damaged and storage and all of that stuff, right? So hopefully people understand what's going on there. So, you can call these twin NFTs. It means that you're buying an NFT that's related to a twin physical product. Okay. And so there is just one more case, and I'm not going to dive into it in the same detail, but there's one more case which is currently still underway, and it's Nike versus StockX.
Oh, interesting.
Yes.
Okay.
Also worth noting, in America, you say versus. In Australia, you say and for civil cases.
Okay. There you go.
So basically, have you heard of Dolce & Gabbana?
Yeah.
So Dolce & Gabbana were one of the first people to do, or one of the first organizations to do these twin NFTs. So they sold 9 twin NFTs linked to physical dresses, and they totaled, so 9, right?
Yeah.
And they totaled $6 million
Okay.
USD in revenue from these. So for example, the highest price dress, I think it had 7 blue sapphires and like 140 diamonds, and it sold for like more than $1 million USD. And it provided those customers with like some specific invitations to upcoming events, et cetera, et cetera. Okay. And so basically, for those of you who aren't aware, just very briefly, I'll just do Nike. So Nike was founded in 1964. What was it originally called?
Tiger shoes?
No.
Tiger.
They were the first shoes that they... I'm
not sure.
In Australia, it's an ice cream brand. Blue Ribbon Sports.
Oh, Blue Ribbon. That's right. Yeah. I did read the book, but
yes.
I forgot.
Great book. So they changed their name in 1971 to Nike, and obviously they supply shoes and apparel, et cetera, et cetera. So worth noting, iconically known for their swoosh. Do you remember how the swoosh was created?
I believe some kind of art student project.
Yes.
They wanted something that was looking like they were moving forward.
Yes.
And sporty and...
Great.
Yeah.
I'll come in from here. So lady named Caroline Davidson is the person you're referring to. Yes, she was, my understanding, she was either a very recent art student who'd started working or was still studying. And so she charged $35 to create the design. Now, this is very contentious, but what's the value of the current Nike logo? Well, I have some valuations that I've seen online, anywhere from 15 to 30 billion US dollars, the value of the Nike swoosh.
Yeah.
That's pretty insane.
Yeah,
they
absolutely.
paid $35 for it.
Yeah, but also it's like you're paying for something which had no value at
Correct.
the time.
No, totally.
And
totally.
It was just a made up, and like it's, it's a pen stroke,
Totally. So StockX, very briefly, founded in 2015, online marketplace for buying and selling rare sneakers and other items. Generally, buyers bid on the items, and once the auction is complete, StockX will take the item, which is where they really come into their own, verify it, and then send it out to the purchaser.
Now that's good for Rolexes, for example.
Yes.
Because there are a lot of fakes, and people that they're not in the market, don't really know what's fake and what's real. So,
no, totally.
Yeah.
Now, in this particular situation, we're talking about their Vault NFT program. We've covered that already as to what it is. And so basically in February 2022, so we're talking a year ago, Nike filed a trademark infringement claim on StockX.
Okay.
The claim had 2 elements. The first one, that use of Nike's sneaker design without permission confused consumers as to the source.
Okay.
And so that's the actual pictured design of the shoe. Second one is infringement and dilution, which we talked about, of Nike's swoosh logo, causing consumers to believe that the NFTs were authorized by Nike. Okay. So swoosh logo, dilution, and then actual sneaker design. Now, this has not been to court as per se yet.
It's just started.
It started a year ago, and it's been through a bunch of mediation, arbitration, negotiation, etc. It's been through a couple of court hearings, is my understanding, but it hasn't been to trial yet. So the really interesting thing is we don't have an outcome from this case, and it may be impacted by the recent case of Hermes and Rothschild. Now, just very, very, very briefly, I'm almost finished here. StockX claimed a defense which is called nominal fair use. Okay. So basically what that means is they raised a defense which in regards to the infringement of the copyright. And this particular defense allows trademark use where it was necessary, no more of it was used than necessary, and where StockX accurately portrayed its relationship with Nike. Now, this is relevant in situations where, and this is going to become very obvious, where you're listing like items for sale on your website, and you obviously have to use a picture of the item. You have to use a description of the item to actually sell the product.
Yeah.
It's called nominal fair use.
Yeah.
Okay. And so, as I said, there's three elements: necessary amount of use and the relationship.
Okay.
So in this situation, obviously the NFTs correspond with specific pairs of shoes. It was not the NFTs themselves. This is the key. The NFTs themselves, this is their argument, was not the product. The NFT simply represented the product. Okay. And so therefore StockX argued that use of the Swish logo in the image was absolutely necessary to depict the shoes. Right?
Makes sense.
In regards to the amount of use, the Nike logo was only displayed on the shoes themselves. And so it appears relatively reasonable. Now, in regards to the relationship, StockX argues that it had a disclaimer, that it disclaimed any association with Nike, but Nike argued that it wasn't enough. Now, there's another defense, and this is kind of interesting, right? The second defense, and this is my very last point, it's for anyone who's been watching this, this is an undercover cop. They drive Chrysler 300C SRTs, and they're one of the best selling cars out there.
Yeah, and he keeps rolling around.
And he keeps running around this. We're on a racetrack.
We're on the racetrack.
Catch that up. And so he's just having a good time. I mean, all power to him. I'd be doing the same, to be honest.
Yeah, he's having fun.
Okay, so one more thing here. You ready?
Continuous.
Sorry, there's a lot
That's
going
all right.
on.
Now
It's all part of it. It's a feature.
That's right. That's right.
Okay, so the second one is first sale doctrine. Okay, so it allows the buying. It allows sellers the ability to sell shoes that bear trademarks after the trademark holder has sold those items. So if you're selling an item in a secondary market, or if you've purchased them wholesale and you're selling them sort of on the primary market, it allows sellers to do that. But this principle or this defense is limited where the resale is likely to confuse customers.
Okay.
As to whether or not the actual company is behind the sale of it. StockX asserts that the transactions, of this Vault project are no different than any other marketplace that includes images and a description of the goods, right? But this is the key here. Nike argues that the NFTs are distinct products in themselves. And the reason for that is price disparity. Now, all that means is Nike states that StockX has sold Nike branded Vault NFTs at prices that are many times the multiple of the value of the underlying shoes.
Okay. But the secondary value or the original retail value?
The original retail value.
Okay.
So what they're claiming is that, and I guess the interesting thing here is leave it at that for the minute. What they're claiming is there's a major disconnect between the price of the physical shoes, what they're asserting should be the price of the original shoes, and the price that's actually being paid for the digital option to redeem the shoes. So they're claiming that this demonstrates that the consumer considers the Vault NFT to be a unique asset with a distinct value that's separate to the physical shoes. If the Vault NFTs are distinct from the shoes, that could defeat the defense and imply that the NFT is a product in and of itself. Now, if that is the case, then you simply apply the principles of Hermes and Rothschilds as to whether or not it confuses consumers. If it does, then it's infringing on intellectual property rights potentially. If it doesn't, then there's potentially no claim.
Wow. So it's a precedent.
So the Hermes case is potentially a precedent that may or may not end up solving this Nike case, which is really interesting.
I think that would really show causation.
So that is an unusual segment. I've never done a law-related segment before, but
that was really good.
I'm really hoping that is interesting to people. I tried to explain it in a way that was consumable because I know sometimes the way judges write is difficult to read. So that is that. I think it's interesting. I think it's an interesting space to watch. It's something I'm interested in. There's other cases. There's another case, for example, that comes out of Singapore as to whether or not NFT can even be decided as property.
Yeah.
Is it property or not? That's a really interesting case as well.
Yeah.
So thank you very much for listening. That is my segment.
It was a really interesting breakdown of the way that NFTs and the law will intersect. And I think we're going to see even more of that through time, especially with projects like we've previously done another block.
Yes. That's right. There's a lot of questions there. Like, not making any statements, but you're listing an item for sale as a unique product, and it may or may not have art, or it may have the name of a song. Is that song copyright? Is the name of that song copyright? Is that infringing on the copyright by selling it as a unique product? I don't know.
We know that they've had a lot of problems with negotiating with OpenSea just because they don't want to copyright infringe and then allow copyright infringement on their platform, everything like that.
This is the nature of new technology, and the law this is the tension that's required to really sort of govern new technology.
Absolutely.
So, it's great. I think it's really cool.
I agree.